Okay, number 5. Let's see where we're at this point. Uses to land developed over time as lords wanted more control over their interest in land, as in an estate. The common law was limited in remedy and slow to hear issues concerning disputes over land, what was being subdivided into smaller states of beneficial and usufruct interest. All right, let's see if we can. Well, maybe I'll read because I just read the first couple of words, and maybe I'll incorporate into what I just said. I can condense it all into or explain it more and develop from there what I want to speak about, how the Roman Church is involved, and so forth. The Roman Church was initially the predominant user of land that could be held in perpetuity under this corporation. The Roman Church was not subject to the common law or could hold the legal title in common law because the legal title was annexed to a personal service owed by each individual in honor and grace. All right. The Roman Church was initially a predominant user of land, and there it is. Now, there's that what creates a use? Well, we already said the barons had a use to land. They could never own land absolute or allodium. They could not hold a higher interest than what the king held. It was impossible. And the lords could not hold a higher interest to which the barons held, or the tenants in chief. Okay? Each one had a legal personage into which their duties and powers were confined within. They could not go past those boundaries. But as time evolved, and you had different kings and so forth, some kings were a little meaner and a little more um, dictatorial than others. And it was up to the barons to ascertain when the king was overstepping those rights that were already developed through the agreements that have started from 1066, and let's move right to 1256, the Magna Carta, when the barons said, hey, that's enough with King John, who was now being too overpowering, whereby, let's say, well, my firstborn son was the one that had the first right, and maybe the king said, well, I don't like your son. He's a pansy, okay? He's not going to I don't think he's going to be able to hold that territorial manor together, so he's not going to provide me the proper service, and therefore I'm just going to usurp that land right from him, whether he has a firstborn or son, or he may be, I want more out of you. Like, yeah, you only have 40 days a year in which to provide night service, but I want now 50 days. But I don't know, it doesn't matter what the problems that developed during those times, but it just come to the point that there was much dissension within the group, to which brought the barons together and say, hey, enough's enough, okay? And the Magna Carta, that's not your agreement. As you will see, each thing's an agreement developed based on the legal personage which is used in English law. The Magna Carta is between the barons and the chancellor, or the Roman Church being the witness of what is, of natural law, what is to be held in that feature, the spirit of man, between the barons and the monarchy. The lords weren't even predominantly involved in the Magna Carta, because again they were under the tenants in chief, or under the barons. They had their own agreement, and they had the hierarchical order to only answer the barons. They couldn't go directly to the king. Now, so that if people go and say, well, I'm using the Magna Carta, geez, it's not 1256, I don't think. Well, it's been so while, but you know what it is. And that's not your agreement. You don't want to be in that agreement because you're not a baron, so stop it. Yes, things were extracted, some principles were extracted, but you'll find that there's principles extracted from all common law, and then to create equity, to which now you're involved in now. Things are extracted, predominant features, in order to create a synchronicity of where they came from, to which then give power to the new agreement that was made And that's the same thing with the Magna Carta. There were some things within that made sense to drive the principles of that could stand upon Parliament to use, and then use those principles to affect agreements within their citizens or citizenships. Okay, so the Roman law was a corporation. Look at 1290, Edward I, I guess, was the king, and what it stopped was the rights of the Roman Church to control land outside of the rights of the king. And that was another thing that happened over time, where you had a duty and a power as a lord or a baron and so forth, the same as you had one as a villein or a serf or a peasant. You had to provide a service to the hierarchical system in order to keep the entire manor running effectively. You had to pick so much fruit, make so many products of metal. You had to provide so much service, whatever that was, so that the entirety of the land holding could then feed the purse of the king, that then could use to pay or use to grant to acquire more power for the king by having a purse that could be used to buy things, let's say, and trade things with other realms or other kings and things that were not under English law. Okay. So, excuse me. Where was I going with that? The Roman Church was, what came to pass was that if you were allowed to give up a certain interest in that manner to the church, to the corporation, that was outside of what you owed to the king for, and maybe we'll have to develop that a little bit. There were, even besides the service that you had to provide, which came out were wardships, incidents, were what we just commonly term as taxes today. You had to give 1/3 or so of that interest and pay at the time of your death. So the next in line, we call it the entail, the next in line had to settle all the debts and so forth of the father, whatever those debts were, to the king before that settlement was then passed on to fully onto the next entail, or the inheritance or the beneficiary of that manor. So they were in charge of, and even the lords, same thing, they had to pay when the predominant lord died, and that interest or inheritance went into the firstborn son. That firstborn son was now left with settling it. So as you see, he had a lesser interest in his father because he had to now settle all those debts and pay those taxes, which are called incidents, and provide wardships before he was able to have fully that land. And if he wasn't able to pay, well, it didn't matter anyway, it's cheated back to the king. So the idea was to give away some of that land away to the corporation, and that corporation was not subject to common law because it was itself outside the common law. As I mentioned, the common law was inherently an individual agreement, predominantly between baron and king, and as you know, the hierarchical system down from there on. So those are all agreements within themselves. So a corporation was a perpetuity instrument. It never died. So it couldn't ever be bound to paying incidents and warships and so forth at the time of death because it never died. And that was the feature of a corporation, of the Roman Church. It's that which never died. Unlike a baron would die, and then the laws of inheritance would ensue, and then that would create the movement of transfer of values and settlement of debts to the king. But there was none of that with the corporation because it never died. So what had happened is that now more lords were trying to transfer more of the land over to the corporation. So 1290 was a law of Mortmain which stopped that right to do so without first having the king's permission. And that's how we started with the uses idea, where we'll start moving into equity, because the use never died. The use was something outside of common law in order to effect a right to control and land interest outside the common law. And there we'll go, we'll stop right there, and we'll go into number 6.